Okay, welcome back, everyone. We will resume with review of the Citizenship Bill. And I'll ask the CPC to similarly take us through and pause for any questions or comments. CPC?
Thank you, Chair. First of all, to summarize the principal changes made to the sought to be made to the legislation, you would note that the grounds for citizenship have increased. So, for example, citizenship by descent may be extended to great-grandchildren. Citizenship by descent may be extended by either parent. And the bill also provides for application for citizenship after a certain amount of time as a permanent resident. It also aligns the oath of allegiance with the oath in the Constitution, and it provides for the reclamation of citizenship after citizenship is renounced for whatever reason. So to take you through now to the individual clauses of the bill. Well, of course, Clause 1 provides the short title. Clause 2 provides the definitions for the terms used in the bill, and of note in particular would be the definition of child, the definition of dependent, which captures spouses as well as persons who are under the age of 18 years, and persons who are relatives, and they might have reached, they might be older than 18 years, but because of any infirmity of body or mind, any disability, they're wholly dependent on another person for subsistence. I just pause here in case anyone has any questions on Clause 2 before moving on. The definitions, yes. If there's any comment. All right, if not, getting into the heart of the thing, Clause 3 provides the additional grounds on which citizenship may be acquired. And we say additional because, of course, the grounds in the Constitution still apply. So Clause 3.1, for example, replaces the existing Clause 4.1 and speaks to, well, it's just a refinement, really, when you think about it, providing for a newborn infant found abandoned in Barbados to be deemed to have been born in Barbados and therefore entitled to citizenship unless there's evidence to the contrary. Clause 3.2 provides for a person who was born outside Barbados and who is a grandchild or great-grandchild of a citizen of Barbados to apply for citizenship, to apply to be registered as a citizen. All of this is subject to Clause 4, which we'll discuss shortly. Clause 3.3 allows for a person who was granted citizenship, permanent resident status under the current Immigration Act to apply for citizenship as well. Clause 3.4 is essentially a transitional provision in the sense that a person who obtained immigrant status under the former Immigration Act and was in Barbados for a period exceeding 3 years is entitled to register as a citizen upon the commencement of this new legislation. Clause 3.5 It speaks to the forms, the fees, etc., for registration as a citizen, and it covers a lot of what is already in the the Barbados Citizenship Act. It speaks to persons who are nationals of a member state, and here member state would refer to the member states of the Caribbean community. By birth, descent, or naturalization, they can apply, as well as the spouse and dependents of such a person, which is consistent with Barbados' obligations under the revised Treaty of Chaguaramas. There are also some periods, some what I would call qualifying periods of stay that are required in certain cases for the granting of citizenship, as you see by clause 3.6. And just also to mention that there are a group of persons who are also entitled upon application to be registered as citizens based on, I would say based on their, let's go to the schedule. If you look at the schedule, you will see there a lot of it has to do with the regional nature of the positions the persons would have held. Like, for example, chancellors, former chancellors and vice chancellors of the University of the West Indies, former heads of states, of member states, etc., spouses and dependents of those persons. Clause 4, to which clause 3 is subject, speaks about the right of refusal to register a person as a citizen. And one of the principal considerations is national security and public policy. In the interest of national security and public policy, the minister may refuse to register as a citizen of Barbados a person who, for example, who's been convicted by a competent court, who's engaged in activities within or outside Barbados, which in the opinion of the minister are prejudicial to the safety of Barbados or to the maintenance of law and public order, who doesn't have sufficient means to support himself, which is consistent with the policy in the immigration bill we discussed earlier today. Clause 5 speaks to the registration of minors as citizens. And the application is to be made by the minor's parent or guardian. Clause 5.2 allows the minister in special circumstances to cause any minor to be registered as a citizen of Barbados. Clause 6 speaks to the certificates of registration, which again is similar to what obtains now. Clause 7 speaks to the effect of registration as a citizen, essentially. Once you're registered as a citizen of Barbados, in other words, the person becomes a citizen from the date on which they're registered. So it's more. Part 3 of the bill speaks to the loss of citizenship, and I explained that in this sense there have been some changes in that a person can now, once a person loses citizenship, they in certain circumstances can reclaim citizenship. But let's go first to clause 8, which speaks to the fact that the person can indeed renounce citizenship in certain circumstances, for example, where they intend to become a citizen of a foreign country. And once the minister registers the renunciation, the person ceases to be a citizen from that date, from the date of the registration. The proviso, however, is that in certain circumstances, the minister may withhold registration where, for example, the person intends to become a citizen of a foreign country during any war in which Barbados is engaged. Clause 9 speaks to deprivation of citizenship. For example, if a person provided false information in order to get their citizen, to become registered as a citizen, then their citizenship can be deprived. Then they can be deprived of their citizenship, sorry. Also, if the person commits certain types of offenses, for example, treason, and they haven't received a pardon. Some of the other provisions would include things like what you would relate to war times, for example, if a person traded with the enemy, in other words, it does something that does not show, that is contrary to allegiance to Barbados.
Sorry, I was going to hold my, I was going to hold my observations on the legislation to the end because it's quite short. But I just wanted to ask, Clause 9, deprivation of citizenship is retained from the existing legislation? Because it seems quite colonial. Meaning, I mean, I don't know the last time somebody was convicted of high treason. You all will have to advise me. But generally, so a person being convicted in a foreign country of a criminal offense of which the death penalty or a term of imprisonment of not less than 7 years may be imposed is grounds for citizenship to be deprived. So citizenship is, so I'm on this planet floating around unless I am anchored to some sovereign nation, right? So it's no small thing. So I've gone to a foreign country and I've been convicted of a criminal offense of which the death penalty or a term of imprisonment of not less than 7 years, which is quite short, as the jail term goes. On that basis of being convicted in another country of a crime where I have been sentenced to 7 years or more, my citizenship can be stripped. Is that what this is saying? Okay, so can you explain what it's saying?
You mean you're a citizen of Barbados and Barbados can strip your city? Are you saying that as a citizen of Barbados, that this is speaking to stripping you of your citizenship?
So perhaps you can just explain deprivation of citizenship as outlined at 9. What is this speaking to? Because perhaps I'm reading it incorrectly.
If you have been granted citizenship of Barbados and you are a citizen of another country and you commit those offenses, yes, but a citizen of Barbados cannot be deprived of his citizenship no matter what he does.
I think it is the drafting style may confuse people because in order to appreciate that, then you have to go to section 2, 3, 4, 5.1 or 5.2 of the Constitution to exclude those persons who are made citizens under those provisions. And then anyone else, this provision applies. So that just is more, I like that phraseology that you use, persons who are granted citizenship, rather than persons who have birthright citizenship, because that would not apply to somebody who was born naturally in Barbados.
Yes, thank you. And to answer your question, yes, it is in the current, a lot of it is in the current legislation. We are not saying that we should not revisit if necessary. We are quite happy to revisit and improve legislation. And with respect to some of the offenses, there are some old laws. We see that happening even in the United States now, not necessarily in the context that one might have anticipated, but the thing is, there's a reason that some of the old laws continue to be used, because one never knows. Okay. Clause 10 speaks to deprivation of citizenship of Barbados, where a person is deprived of citizenship elsewhere. So, for example, if the person is deprived of citizenship in the other country on grounds which are similar to those grounds on which Barbados would have deprived them of citizenship, then the minister may deprive such a person of citizenship as well. And the person does get an opportunity to explain himself. Clause 11 speaks to resumption of citizenship, where, for example, the person has made a declaration to renounce citizenship. They can resume the citizenship where they satisfy the minister that at the time the declaration was made, they were about to become a citizen of another country, and they could not have remained a citizen of Barbados and still become a citizen of that country. And also that they had reasonable cause to believe that they would have been deprived of citizenship of that country had they not renounced citizenship of Barbados. Part 4, miscellaneous, speaks to the certificate of citizenship. Provision for the certificate of citizenship being essentially the undoubtable proof that a person is a citizen of Barbados, unless, of course, there was fraud involved or something of that nature. And clause 12 again speaks to the minister's discretion not being questioned in terms of any reason for granting or refusing an application for citizenship under the legislation, and the minister's decision being final. I believe that in relation to the immigration bill, there was some discussion on these issues, so we are mindful of those discussions. Clause 14 speaks to evidence, what is essentially taken as prima facie evidence in certain cases. For example, what's on the record, the notices, the certificates, the oath of allegiance, etc., being received in evidence unless the contrary is proved. Clause 15 provides for the minister to make regulations to give effect to the legislation, including for fees and for the registration, as well as for the cancellation and amendment of certificates, etc. Clause 16 provides for the minister to amend or vary or revoke the first schedule. Clause 17 provides offenses related to the act, for example, giving false, making any false statement. 18 provides for the oath of allegiance, which, as I explained, is now aligned with the oath in the Constitution. clause 19, because the current legislation is being repealed by clause 20. Clause 19 provides a transitional provision to deal with matters that are still live. So for example, any application for the grant of citizenship of Barbados or for registration as a citizen that started under what would be the old legislation then, but was not completed before the commencement of this new legislation, will be deemed to be an application for citizenship under this current legislation. So everything just continues. And clause 20, I spoke to clause 20 already. Clause 21 provides for the legislation to come into effect by proclamation. We went through the list in the first schedule. We looked at the first schedule, and the oath of allegiance is in the second schedule. And that is essentially the bill.
Thanks very much. Questions, comments, observations?
Yeah, of course, I got a question on clause 13. A very unusual clause, and I know that the CPC made aware that this is part of the drafting instructions that they would have received, but I'm not understanding why a clause like this will pass muster from even a drafter, knowing what courts have said about these kinds of clauses in any event. And I'm not sure if it is taking the form of, it's not outright ouster clause, but it does something more than oust the jurisdiction of the court. It basically says that this is an unfettered power. I can understand why the minister may not be questioned on the determination of citizenship issues, which will concern national interests, not only national security interests. But at least when Parliament gives that power, it should come within the context of a policy that it is being delegated to be administered by Parliament to the minister in a way that Parliament retains some control over the power that is being given. When we talk about the separation of powers, and for Parliament to give up that power and then there is no ability at all, not only is the minister not required to answer, he's not required to give a reason. So that I don't understand the legal or jurisprudential basis for an untrammeled, unfettered ministerial discretion in law. I don't understand it. But I can understand, as I said, if there are national interests or national security interests, which would buttress the administration of this power, it would then give the courts, which are the last bastion of one's protection in the society, the ability to say with deference to the executive, these are macro issues that a judge may not necessarily want to delve into, or if the judge sees this information in private without the parties who are before the court participating in seeing what is the information the state is providing, at the very least, those are some comforts. But the way this clause is drafted, it seems that once Parliament gives up this power, there is no way in which that power can ever be restrained or restricted or controlled. So it is, I know it is a policy issue, but certainly from a drafting standpoint, is this meant to be certainly an immunity provision as opposed to an ouster clause?
Thank you for your comment. To respond in terms of the discretion given to the minister, when we went through the bill, you would have realized that in certain cases we did refer to national security interests, etc., public order. So there is some constraint on the power. We take the comments that you've made, and I think it's worth revisiting, certainly. No, but...
Sorry to interrupt, but I'm just asking a question in the context of what Senator Nichols just said. So this clause refers to administrative recourse? Because I'm getting I am taking from what Senator Nichols says that it means that that any decision of the minister is not subject to any judicial recourse at all, which I wouldn't imagine is the case. I would think that this relates to any administrative recourse, meaning any civil kind of tribunal, but surely any matter could be the subject of judicial review. The lawyers would other lawyers and those in CPC's office would have to.
The challenge with this is that currently under the Administrative Justice Act, these issues are not reviewable. So when the act was passed in 1982, the matters under the Immigration Act and Citizenship Act and a number of other things, I think the Defense Act as well, they certainly were exempted, so the courts could not go into a process of judicial review, which is the court exercising a supervisory jurisdiction to make sure that public bodies are acting in accordance with the law, and that decisions taken by public bodies are within the four corners of the law. Those statutes were exempted from judicial review. Now, the way in which the courts have, or I should say recently, have used the wide berth of the Constitution to get around these so-called ouster clauses or immunity clauses has been a welcome fillip to the law, because the right to protection of the law is a constitutional right, and the courts have interpreted that broadly. But my challenge is that we seem now to be in this here doubling down on, at least I will be comfortable where the minister is required at the very least to state what the basis of the determination was if it were to be questioned, if the legality of the minister's actions are being questioned by any citizen or anyone through the courts. And even if the minister had to give redacted information to the court and not necessarily to the other side, where the judge, who is the last bastion of protection for people, will make a determination that in the public interest, I don't have to disclose this to the applicant or to the citizen. I am satisfied that the state has made out a case on an application for the grant or refusal of any matter under this act, that the other side does not have to know, or in the national interest, they don't have to know. But you are saying that the minister does not have to give any reason. Now, this lends to potential abuse, which Parliament itself, in giving up this power, because Parliament is the lawmaker, gives this power to a minister. So when it is abused and the minister is acting outside of the law, we already have indicated that this is not a place where you can get judicial review from. So the courts have always said that we will respect the actions of the ministers when they are acting within their lawful province. So this clause would only make sense if it were an ouster clause, if the minister were acting lawfully. But it goes before there. What I mean is that is when the minister is saying, well, this is the reason why he acted. So the court can say, okay, the minister was acting lawfully, that is the end of the process, this matter can't proceed to trial. But it's saying here that the minister is not required to sign any reason. So the courts will be blind. So the courts cannot inquire into the validity of the legality of the minister's actions because the minister does not have to assign any reason for his or her decision. And that is, to my mind, overly balances the powers in the hands of the state. And I will say that from my perspective, this is not speaking about current ministers or how the system is managed, no, but it opens up for potential abuse. And once that abuse becomes manifest, we are seeing things happen in other countries where even the courts are being accused of having a political bias. But we're taking out the courts altogether in a small country where this provision could be misused 10 years from now, where the minister can grant citizenship or even revoke citizenship to persons. And I'm not entirely comfortable with it unless it comes with some statutory provisions which guide how this process of review can be dealt with.
Thank you. We agree with you that despite all of what is said in Clause 13, the courts certainly have found ways to circumvent such provisions, and we also accept, of course, that the citizenship and immigration fall outside of the administration of justice legislation. So we take the point. Perhaps it is one that we need to revisit.
If I may add something with your permission, I think that these clauses, they've been referred to as ouster clauses. The court has always examined them, and precisely what was enunciated. If it's a matter, and in all of these cases, it's a matter of almost a state secret why the minister deprives or takes away citizenship. You go to the court and the public documents will have to be examined by the judge himself, who would not disclose a reason, because the minister cannot disclose a reason if it would be inimical to the interests of the state. And when the courts examine it, then the judge will have to be given the documents so that he himself or herself can review them and agree or disagree. And that is how these things work. Now, whether this provision can be amplified is a matter for further consideration. But that is where the law stands. And I agree with you that that is where the law stands.
So I think Justice Moore even said it more succinctly than I could have said it. But I'm talking about where there is a rogue minister or a rogue administration which will say, I am not going to court because the law says I don't have to assign any reason, and interprets this provision to tell the courts it is none of your business. Now, what Justice Moore is saying is exactly how the system runs with the system that respects the rule of law. So even though the Act may say that the minister's actions can't be inquired into, where there's a question of the constitutionality or the legality of the minister's action and is brought before the courts would do exactly what Justice Moore said. Providing the information, the other side doesn't have to see it. The judge alone will look at it and hand it back to the state and make a determination. But what happens when there is a rogue minister or a rogue administration which says, the Act tells me that I don't have to give a reason, I'm not going to any court?
one last word. Anytime the court makes an order and anybody refuses to obey that order, he can be arrested, taken before the court, and proceeded against for contempt of court and sent to prison.
I think this exchange goes to my question about whether this clause means whether a court is also subject to this clause, which in my mind it is not. So that's why I was making the distinction between an administrative process. To me, this suggests that a minister is not required as a part of the administration of this. The regular administration of this legislation is not required to provide to the applicant or to any third party in the administrative process a reason, but certainly that a reason must, to the extent that this may appear before the court, a reason must or should be provided. So that's why I was asking the question about whether this, because I cannot imagine a scenario in which an individual can say, a court has made an order for information, and an individual can say, well, no, this tells me that I don't have to answer you. As a separate matter, if we think that this is very strong language with respect to the administrative process, then I think we can review it. But I don't think that this is meant to invalidate the rulings of the court. Are there any other questions, observations? It's a very quiet committee. I have a question that relates to the process for how these two bills hang together, because the citizenship bill is quite short, and it makes reference to a permanent resident being able to apply for citizenship. So it seems to me as if the two are part of this of a process, meaning to say that, and tell me if I'm reading this correctly because I may not be understanding, is that a person who has satisfied the requirements for being a permanent resident and who has achieved that status can then apply for citizenship under certain conditions. Is that, I'm not sure which, I would have to go back and see which clause it is. But that seems to me, yes, please.
I'm just trying to find the provision for you. Right. Clause 3, 3.3 says, subject to section 4, a person who is granted permanent residence under section 5.2c of the former Immigration Act is entitled upon application to the minister in the prescribed form to be registered as a citizen. That's one.
Can you explain to me what that means?
Okay, let's pull it up.
Because that would mean that a person who was granted permanent residence under 5.2c. Can we just refer to 5.2c, please?
Right. I'm pulling up 5.2c as well.
Of the former Immigration Act is entitled it's the former Immigration Act,
The current one.
the current Immigration Act.
Or I believe 52C might be in one of the amendments, so I'm just checking.
So when we look at this law as the law, what's this policy, the current one we're looking for?
I think, what, I'm sorry. What I'm trying to establish here is so what I'm trying to establish at the start of your presentation, you mentioned that this legislation seeks to expand the categories or circumstances under which citizenship may be granted. And so what I'm trying to establish for the purposes of this committee is what those categories or circumstances are, because the legislation as written makes so much reference to other things that, you know, one has to be sure, you know, what we're talking about. So for example, an individual who is at 3-4, any person who on the day immediately preceding the commencement of this act is an immigrant having obtained that status under the former Immigration Act and had been an immigrant for a period exceeding 3 years shall be entitled to be registered as a citizen of Barbados. So a person who had what was formerly known as immigrant status, which was another curiosity under the former law, would would immediately qualify to be registered as a citizen. So I'm trying to establish these categories because I think that there's some things that because the legislation makes reference to other parts of legislation that we're not clear on. So I'm trying to understand the permanent resident path to citizenship. That's what I'm trying to make clear. So I'm trying to understand, under this legislation, it makes reference to the notion that a person who has achieved the status of permanent residence for some period may apply for citizenship. And I'm trying to understand how the two fit together. Because we're remembering that the immigration legislation that is before us also now allows a person to qualify for permanent residence based on this point system. So strictly speaking, a person can then also, on the permanent residence pathway, then also apply for citizenship on the basis of that point system, because it is really just a kind of a 3-year interim period, and then you can become a citizen. And I think that for the purposes of our conversation, we need to understand that pathway, because I'm not sure that I'm clear on that pathway.
Thank you. I am thinking that there might have been a bit of a typographical error here. The 5.2c looks, when we see 2c in brackets, it suggests that it's a subclause. No? Okay. I'll let my colleague explain then.
This is not I can't find that amendment among the papers I have. I have to find the 5.2c that is here is a different, 5.2, it means that there were subsections added to section 5, and one of those subsections is 2C. We don't currently have that before us. So we'd have to review that, find a copy and let you have it. Because
And at clause 3.6, the following persons may, upon application to the minister in the prescribed form and upon payment of the prescribed fee, be registered as citizens of Barbados. A person who is not a national of a member state, the spouse of the person referred to in paragraph A, dependents of the person referred to in paragraph A, if they satisfy the minister that they have lawfully resided in Barbados as permanent residents of Barbados for an aggregate period of at least 270 days during the period of at least 1,095 days immediately preceding the date of application. So it means that under the point system, been granted permanent resident status, and have been living in Barbados under that status for approximately 9 months out of 3 years, immediately preceding the date of application. And on that basis, I can become a citizen.
period is a bit shorter for if the person is a national of a member state, which is what, 5 tries to capture.
Sure, and I'll be frank with you, a national of a member state of CARICOM might as well be a citizen. That I personally, my challenge does not come in the case of CARICOM members. You live in St. Lucia, you live in Barbados, it doesn't matter to me. Quite frankly, I think that's the spirit of the revised treaty, and that's how it should be taken. Where I think we have to consider the point system and the basis for the awarding of points to be a permanent resident, that is the pathway to citizenship. So, while this is its own legislation, the truth is that, and the reason we're considering the two together is that, strictly speaking, if under the point system, which looks at qualifications, age, assets, and under that system, I'm awarded permanent resident status, and then within 3 years, I become a citizen. That is the question that we are considering, and that I'm sure others will come and share with us how they feel about that system. Because that is a easily acquired threshold, I think. And I think that the reason that we would want the minister here in our next session is to be able to talk through that kind of policy perspective. But I'll stop there. If there are no other questions or observations on the legislation, I think we can adjourn this particular meeting. I know our agenda suggested that we would consider written presentations and also discuss the scheduling of oral presentations. I would like to suggest, based on representation made by members of the committee, that we defer the consideration of written presentations, but I would like us to discuss before we adjourn the request for oral presentations and their scheduling. If I could ask the clerk and the team. Well, I'd like us to know, so that we can understand how many oral presentations at least how many?
There has been a request only for one oral presentation. I thought what I had seen, it wasn't really. There's only one. Point Order Bill 1. Madam Chair, if we take, there will be four requests for presentation. The borough wants to make one. We have the New National Party, and these are the two individuals who misunderstood the process. So I would say four. So we can schedule. Once the committee agrees, when next, and we will just rate the persons.
In our next meeting, we will need to have read and consider the written presentations. And I think we might be able to take oral presentations on that day as well. I would like to suggest that we meet this Friday. I think that this legislation is critical in nature. And I propose that we not delay or prolong the work of the committee in this regard. So if we will be able to meet on Friday, are members available or not available? Silence means consent. So I suggest Friday at 10 a.m. All right.
Know what time in terms of the oral presentation? We need to give them a specific time.
Also, Madam Chair, do we take into consideration notice for those that are given oral presentations?
Yeah, I think that what I would suggest that we do is that we reach out to those who first requested, to ask them today if they are available, and then go through the list. And whomever is available, then we schedule. But in any event, I would like us to meet on Friday, even if just to settle the written presentations. Proposing that we start the oral presentations at, I would say at noon. Yeah. All right, is there any other business that anyone wants to raise? If not, thank you kindly. Could somebody move that we adjourn this meeting?
I so move.
Until Friday at 10, second? Who seconded?
Second, Madam Chair.
Thank you very much. And we are adjourned. Thanks so much. Have a great afternoon.